the importance of having a contract in writing, again, a valid contract is simply three elements: offer, acceptance, and consideration, which is something of value that's bargained for. Now, a contract does not have to be in writing to be enforced. However, there are some exceptions, and the exceptions are known as the statute of frauds. 6 types of contracts must be evidenced by a signed writing to satisfy the statute of frauds. You can remember those by using an acronym known as MyLegs. The first is contracts for marriage. These were popular in England, but they're actually void in America as a matter of public policy. But if you had a contract for marriage, it would need to be in a signed writing to satisfy the statute of frauds. Year, contracts that cannot be performed within a year must be in writing. Land, because land is so rare, every parcel of land is different. Every contract for the sale of land must be in writing. Executor contracts, contracts for the sale of goods greater than $500, according to the UCC, must be in writing. And finally, suretyships and guarantor contracts. Those are contracts where one person guarantees the debt of another. For example, if the CEO of a corporation, say Jeff Bezos, if Amazon takes out several loans for new business adventures and expansion, Jeff Bezos might be the guarantor of that loan. And if he agrees to pay the loan in the event that Amazon cannot, that guarantor agreement would need to be in writing. So if you remember MyLegs, those are the contracts that must be in writing to satisfy the statute of frauds. Let's take a look at your Module 4 assignment. In this scenario, Jill and Will are independent contractors. They have completed technology projects for people and businesses. They have not sold parts because they did not want to have to collect sales tax or deal with the paperwork. In the past, their carefully selected customers have been great. Collection of bills has been easy, and they preferred not to use written bids or contracts. But now they've changed their minds due to their customer needs. They have sought advice from your supervising attorney, Mary. They've even decided that they will sell some big ticket items. So now Jill and Will understand from their own research, contracts where they sell over $500 worth of goods must be in writing, but they would like some more up-to-date, accurate information from the attorney. So your supervising attorney wants you to do a survey of recent cases and articles on the statute of frauds to make sure she has up-to-date legal advice to give her clients. So for Module 4, you're being asked to create a memo. Within your memo, you need to do the following. First, research Lexis Advance and find a recent case on the statute of frauds under the UCC. The best way to do that is to put in quotes in the Lexis Advance search box, statute of frauds. You should also put in the search box, sale of goods or UCC. So that's what you would need in your search engine. Again, look for cases within the last 2 years so that we can have a fresh view of the law, what the law is currently. I don't care what the law was 15 years ago or in a 19 anything, because that was a whole nother century. We need to know what the law is in this decade pertaining to the statute of frauds. You should also obtain a recent article from Rasmussen's online library. If you have a question, contact Dennis, the librarian, to help you do that search. Find a legal blog on the open web about the statute of frauds, and there are many. They're so interesting. A statute of frauds requires a writing that has been enacted in your home state. So be sure to find the statute of frauds, for example, in Minnesota, in Ohio, in Chicago, wherever you live. Cite to the UCC provision in your state It requires the statute of frauds. If all you can find is a statute of frauds pertaining to the sale of land, cite that. Just cite the statute of frauds in your state, whether you live in Texas, Colorado, Florida, cite the statute of frauds in your state. You can find that on Lexis Advance. You could probably find it by Googling it. I bet if you put in statute of frauds in Minnesota, you'd get a hit. You'd probably find the statute. Additionally, for the appellate case on statute of frauds issue, complete and include an IRAC analysis within the memorandum. So the case that you cite in number 1, that case that you find on Lexis Advance, just do a brief IRAC. Let me know what the issue was in the case that you found, the rule about the statute of frauds, the analysis or the application of the statute of frauds to the scenario in the case, and what the court concluded. And hey, if you pick a short case, that means your IRAC is shorter. So for that first case or part 1, you can find a recent case on Lexis Advance that is short. That makes it easier for you to do your IRAC analysis. So just please use Blue Book citations for every source. I know the assignment mentions using a footnote. You do not need to use a footer in this memo. Okay, we do have a graded discussion forum also in Module 4. It is about legalese. We'll talk more about that during the live session. As you know, certain contracts are very complex. Again, that is because our contracts common law was brought over from England. So there's a little bit of some complicated English sometimes that is used in contracts. The modern approach is to simplify that language so that the client and yourself really understand. So what the contracting parties need to do is clear to everyone. So we're moving towards simplification using plain language in contracts. So this is also going to be a great fun assignment. Just get on Google, find an example of a contract that has a lot of old English and legalese in it that is wheretofore and therefore they should and not doubt in their performance that thou may not, and if he doesn't. So look for double language, look for a lot of fancy words and unnecessary prepositions, theretofore, herefore, therefore, and the parties thereunder. Look for something that has a lot of legalese on it, and go ahead and post it in the discussion forum. For your reply post, you want to simplify a classmate's example of the case that they found and make that more readable for the client. Remember, most often the problem is not the legal terms. The problems are too much repetition, double negatives, and complexity. You know, saying Jim may not unwrite the contract. Instead, you should just say, Jim should follow the contract, right? Get rid of double negatives. Short sentences can help. So for this discussion forum, just post the case that you find, the example with a lot of legalese in it. Post that by Tuesday, if you can. Post your reply by Saturday. By all means, post anything that you want graded by Sunday, because when Module 5 starts, the Module 4 discussion forum is over. So make sure you get your posts in by the end of the week. We also have a quiz in Module 4. I just took it and made a 100, and that means you can also make a 100. We will be having a live session and a quiz review Wednesday, 6 p.m., our usual time. We're going to talk about the proper grammar rules and legalese as well. So please use a link that is posted, and I will see you Wednesday at 6 p.m. in the live classroom. Have a great week.